Good morning, colleagues. I think we have a quorum now. My apologies for it is now 9:01. My apologies for starting late. Welcome to the Standing Committee on Local Governments meeting. We have one item on the agenda, and that is considering the our negotiating mandate in relation to the Municipal Structures Act, negotiating mandate regarding the Municipal Systems Act or Amendment Bill B2B stroke 2019. It is the 5th of May. May I take this opportunity to welcome all members present and for record purposes, and to establish our quorum. Could the members on the platform please introduce themselves? I'm the chairperson, Derek America.
Andreas van der Westhuizen, member of the committee.
Any other member? I've
Morning, Chair.
Good morning, Isaac.
I'm a guest, so
yeah. Yep, sure. I see member Makamba Boycha earlier logged on. Did she?
Chair, I noticed that she's on hold, it says.
Honorable Makamba Boycha, can you hear us? IT, is it possible for you to just establish what's the difficulty with Makamba, member Makamba Boycha? I don't think she can hear us. Okay. Jan?
Chairperson, I'm just following up with her.
Okay. Okay. Welcome to the meeting, Honorable Smith. Don't know if you can hear me.
Hello, Chair. Morning, members and Chairperson. Yes, I'm here, Chair. Thank you.
Good morning. Okay, colleagues. I see Makamba Boycha is on the platform. Honorable member, can you introduce yourself, please? Well,
thank you, Chairperson, and good morning to the meeting. My name is Member Makamba Boycha. Thank you, Chair.
thank you so much, Honorable member. Colleagues, once again, please accept my apology for our late start. stuff happens, unfortunately. May I welcome also all our other members on the platform, Senior Procedural Officer, Committee Assistant, our IT personnel, Candice, and also Advocate Marstorp, and our guest from the NCOP, Mr. Isaac Sileku. Colleagues, purpose of our meeting is to finalize our negotiating mandate regarding this systems amendment bill. And may I just take this opportunity to thank Advocate Marstorp for providing us with the invaluable input he provided in the meeting yesterday in a form that Johan could incorporate it in the negotiating mandate. And without further, comments, I think, Johan, I see Honourable van der Westhuizen, I recognize you.
Yes, thank you, Chairperson. Chair, I don't seem to find a copy of the draft negotiating mandate in my inboxes, neither of my email addresses, and I was just wondering whether it was indeed forwarded to us, and if so, if our procedural officer would be so kind just to forward it to me again.
Yeah, thank you, Honourable van der Westhuizen. As part of the meeting invite, those documents were attached to it right at the bottom, so it ought to be there because it was attached to the meeting invite. I don't know if you've checked that. Perhaps we scroll down a little more.
Chair, my apologies. I accepted the meeting, but I was unable to find it on the calendar this morning as well. And Mr. Kutsi was so kind to invite me in again. I will just check and see if I can find it, whether it's been filed under the Teams folder. Perhaps Mr. Kutsi will help me.
Okay, fine. Thanks, colleagues. With that, I'm sure you will send Honourable van der Westhuizen a copy of it. So the meeting is not scheduled for the whole morning. It's one item on the agenda, and Johan, if you could flight the draft report that was circulated to members, and then we can just go through the report and see whether everything that flowed from our discussion yesterday were in fact sort of incorporated in the report. Thank you.
Chairperson, I've shared it. I'll just make it a little bit bigger.
Yep.
And I also forwarded, I sent it again to member van der Westhuizen to his MWeb account, the same as I did the other ones, yeah.
Okay, fantastic. So, colleagues, we're going to go through the report now, and you are of the opinion that it does not incorporate the content of our discussions yesterday, and then certainly we can effect those changes where necessary. Okay, so I'm going to just read through it as slowly as I can, possibly do, and then we deal with each subsection or at a time, and then we can either make the necessary changes, or we can just proceed until we get to the end of the document, and then we can make a decision thereafter. So, the first paragraph says the report of the Standing Committee on Local Government on the Local Government Municipal Systems Amendment Bill B.2B-2019 NCOP dated the 5th of May as follows. The Standing Committee on Local Government, having considered the subject of the Local Government Municipal Amendment Bill, referred to the committee in accordance with Standing Rule 217, confers on the Western Cape delegation in the NCOP the authority to support the bill. The committee further proposes the following amendments. There is nothing controversial about that. 1. General comments. Firstly, the amendment bill requires language editing and formatting. Further, the Commonwealth Convention on Legislative Drafting apply to all forms of legislation, including bills. The amendment bill does not comply with these conventions. Some of the errors or problematic drafting practices contained in the draft amendment bill are as follows. 1.1, Clause 2, incorrect punctuation in Section 5A, open brackets, 10, close brackets, delete inverted commas, and second full stop at the end of the proposed subsection. 1.2, Clause 3, incorrect numbering, Section 56, open brackets 4A, should become 5, and consequential amendment should be brought about. Clause 1.3, Clause 5, 1, incorrect numbering. There is no subclause 2. Delete the subclause numbering. 1.4, Clause 5, open brackets 1, close brackets, open brackets E, close brackets, colon, incorrect wording, delete, and at the end of subclause. 1.5, Clause 5, open brackets 1, open brackets F, close brackets. Incorrect indication of amendment and incorrect punctuation. Delete inverted. Can you scroll down here and go up? Thank you. Delete inverted commas before F and full stop at the end. Add semicolon and. Open, so what do you call it? Anyway, 1.6, Clause 5, 1G, incorrect indication of amendment. Delete inverted commas before G. The provision mentioned above are not the only provisions in which these or other errors appear. It is proposed that the amendment bill should be amended to ensure consistency with accepted legislative drafting practices and Commonwealth Convention. Anything controversial about that, colleagues? The silence suggests not. Thank you. Thank you, Andreas. 2. Comments on specific provisions. 2.1, Clause 1, Amendment of Section 1. The definition of the Principal Act for Political Office Bearer does not include a reference to a whip. The definition should be amended to include a reference to a whip to ensure alignment with the Local Government Municipal Structures Bill B19D of 2018. It is proposed to amend the definition of political office bearer by inserting a reference to whip. There is no definition for the term second or secondment. It is proposed to insert a definition for second or secondment to clarify the conditions. Conditions may be set. Okay. 2.1. any sort of clarity?
Sorry, Chairperson.
Yes.
Yes,
Yeah.
Chairperson, it's Johan here. If I may, if Johan could say, can just scroll back up to point 1 quickly. I just want to mention something there.
Okay, good. Yeah.
Pick up. Yes, they 8.1, Johan, just up to point 1, not 2, the first one that we dealt with. Yes, yes, yeah, in the under point 1 general comments, there's the first paragraph, and yes, and that last sentence of the paragraph mentions the draft amendment bill.
So the draft must be taken out. Yes. Is that correct, Johan? Johan, you're on mute.
Oh, sorry about that, Chairperson. Yes,
Yeah.
it was just that draft that should be deleted there.
Yeah.
It should just be amendment bill.
That's correct, yeah.
Yeah, thank you.
Thank you, Johan, for alerting us to that oversight. Right, we move on to clause 2, and that is 2.2. Substitution of section 54A. This clause deals with the appointment of municipal managers and acting municipal managers. To that end, this clause provides for the situation of section 54A of the Principal Act. I'm sorry for that, colleagues. That's now not intended. Okay. What happened again? My apology. In that regard, clause 54A8 of the bill provides that if a person is appointed as municipal manager in contravention of this section, the MSC for local government must take appropriate steps to enforce compliance by the municipal council with this section, which may include an application to a court for a declaratory order on the validity of the appointment or any other legal action against the municipal council. That's how it is. So, a consideration of the above provision suggests that the MSC is authorized to even approach the court to ensure compliance, and this is commendable. As it accords with the objectives of the bill to professionalize, Johan, they're just the capital professionalize should be lowercase, professionalize councils and to ensure good governance. However, the bill falls short in its follow-through when one considers clause 58A9. This particular clause provides that when MSC for local government failed to take appropriate steps referred to in subsection 8, the minister may take steps contemplated in that section. If one of the objectives of the bill is to ensure compliance and accountability, then it is unclear why it is provided that the MSC is compelled to act, while the minister in turn only has the discretion to do so. In addition to clause 54A8 provides that if a person is appointed as a municipal manager in contravention of this section, the MSC must take steps. The bill is, however, silent on any retributive action to be taken against those who in fact appointed the person in the first place. This flies in the face of ensuring compliance and accountability. Further, the bill provides for the instance where the MSC may fail to take appropriate steps, but inexplicably and mindful of its purported objectives of ensuring compliance, prudent governance, and accountability, the bill is silent on any accountability that should befall the MSC for not taking the appropriate steps. It is proposed to amend section 54A to provide for A, compelling the minister to take appropriate steps where the MSC fails to do so. B, accountability by those who appoint someone contrary to the compliance prescripts. And C, accountability by the MSC where he or she fails to take appropriate steps. The reference, yeah, so that relates to that particular section, and I think it was sort of eloquently stated by Advocate Master in particular, and I thank Advocate Master for highlighting this shortcoming that the proposed amendment should have exposed, and I think that if it is incorporated in the bill, it will enhance good governance and accountability. So colleagues, before I move on to the next paragraph, is any misrepresentation in terms of the discussion of that particular section yesterday? Can I proceed? Is it all in order?
In order, Chair.
Thank you, Andrikas. Advocate Master, does it encapsulate your sort of position that you enunciated yesterday?
It certainly does, Chair. Verbatim, it is as I have submitted it. Thank you.
Thank you very much, sir. Then I move on, colleagues, to the next paragraph. The reference to senior manager in section 54A10 is incorrect as this proposed section deals with municipal manager. So it's just a substitution of where it stated senior manager, it ought to be municipal manager. So it's just straightforward. It's something that it just missed. It is proposed that change the reference to municipal manager. The cross-reference to subsection 7B in section 54A10 is incorrect, and referral should be made to subsection 8. It is proposed to omit cross-referencing to subsection 7B and substitute with cross-reference to subsection A. Right. 2.3, clause 3, substitution of section 54. This is an incomplete cross-reference to section 56.2. It is proposed to include reference to subsection 1A1 in the introductory part. 2.4 is asked, clause 4, amendment of section 54A and 56, section 56. Clause 4 aims to amend the wording in sections 54A and section 56. However, both these sections are substituted in the entirety by the bill, so the amendment is superfluous. It is proposed to delete clause 4. Okay. 2.5, clause 6, substitution of section 57A. This clause with reference to section 57A of the Principal Act deals with the employment of dismissed staff and record of disciplinary proceedings. In particular, clause 6.9 provides that the minister must maintain a record of all staff members that have A, been dismissed for misconduct, or B, resigned prior to the finalization of the disciplinary proceedings, which record must be made available to municipalities as prescribed. It is observed that there are numerous instances where staff resign from the employment of a municipality before they are subjected to disciplinary proceedings where there are allegations of misconduct against them. Again, in the interest of the bill purported objectives of ensuring accountability and good governance, and to ensure the the prudent management of public funds, it is unclear why the bill is silent on obliging a municipal council to, notwithstanding the resignation of a staff member, still institute legal proceedings within a certain time frame for the recovery of public funds. It is proposed that by expressly providing for specific time frames within which this must happen will underscore the bill's objective of vigilant financial management and clean governance. Next page, John. So clause 10, insertion of section 7(1)(b). This clause, okay, it's a new section. Just going back to the previous section, please. Okay, thank you. That's clause 6, substitution of section 54A. Blah, blah, blah. Any comments regarding that, Andrikas?
Thank you, Honourable Chair. Chair, just a few questions that I have. Again, I'm in full support of what this paragraph 2.5 is highlighting and wants to achieve. My first question is just under there in bold B, resigned prior to the finalization of the disciplinary proceedings. I'm just wondering whether we have clarity on what date does this do disciplinary proceedings start. You know, in terms of the current legislation and regulations, actually, it's contained in regulations. If a complaint is lodged about possible misconduct, then such a staff member is normally given a day or so to submit reasons why he or she, for example, should not be suspended. But at that time, normally, you know, formal charges have not been put to such a staff member. And I'm just wondering, you know, if a person then resigns at that stage, if that would already be seen as whether disciplinary proceedings have started. So I'm just asking whether we shouldn't be quite clear on when does disciplinary proceedings start, because as I've now indicated, the presenting somebody with a charge sheet often takes a number of weeks, because obviously there's some investigations that need to be done. And if we see the start of disciplinary proceedings only once, you know, for example, a chair of the disciplinary proceedings is appointed, or the person is presented with a charge sheet, or presented with a date to appear, etc., then I think this may not achieve what we want to achieve by this clause. And then, while I have the floor, Chair, if we go down 2 paragraphs, the paragraph starting with, again, in the interest of the bill purported, then, and I know this is just the motivation why it is needed. If I was just wondering whether we shouldn't add at the end of that paragraph, within a certain time frame for the recovery of public funds, and whether we shouldn't just say public funds lost due to alleged mismanagement or misconduct. You know, not all cases of misconduct lead to public funds being lost, and sometimes it's quite difficult to also obviously calculate how much has been lost due to that conduct. But I'm just wondering whether we shouldn't be specific for the recovery of public funds lost due to mismanagement or misconduct. I'm looking forward to the responses of other members and Advocate Marsdorp. Thank you, Chair.
Okay, thank you, Andrikas. They did spark that addition there. Quickly, we'll get back to it, but let's move back to the previous paragraph, Jan. With regard, in legislation, one cannot be, you know, hand all the specificities of a particular set of objectives that we have in mind, because those will be contained in regulations, and I think Advocate Master can guide us there with regard to. Jan, can you just move up a little, please, to the previous clause? More higher, that you get, that we can stop there. With regard to B, in terms of when related to the question posed by Andricus, Advocate Master, I very much appreciate your legal sort of interpretation and mind here to guide us. Jan, Andricus, Andricus, I see your thing is flashing your mic. Okay, good. Advocate Master.
Chairperson, the
Yes,
definition of disciplinary proceedings is contained somewhere else in legislation, but it may even be that in a municipality's specific disciplinary code or code of conduct, there may be a definition as to what constitutes, what comprises disciplinary proceedings. Ordinarily, disciplinary proceedings would be deemed to be those proceedings which commence the moment a charge sheet is submitted to an accused person. So one would draw from that general principle that, and the charge sheet, of course, can only be submitted or processed if an investigation is done. And what frequently happens, as Chair more than I would know, is that once a staff member realizes that an investigation is pending or ongoing or imminent, then that staff member, in anticipation of the conclusion of the investigation, would resign. So that ordinarily is a good indication that a staff member resigns prior to the finalization of proceedings. So, like I said, it would be difficult to incorporate a comprehensive, definitive definition here for what disciplinary proceedings are, but I can assure Chair and the member, I think it's a very good observation by Member van der Westhuizen. I can assure you that the definition of proceedings, disciplinary proceedings, is certainly contained in a code. If it is not, one would resort to either the common law or to legislation, which would include the labor relations related legislation. For now, I think it may be slightly out of place to include it here because, like I said, there are other legislative instruments which sufficiently define what the disciplinary proceedings are.
Thank you, Advocate Master. Andricus, are you reasonably satisfied with the response?
Yes, thank you, Chair. While Advocate Master was speaking, I also realized that quite often, you know, our local government arena or sphere is highly contested, and quite often, you know, people are also subjected to frivolous complaints and so on. And I think his explanation that the disciplinary proceedings normally probably, or the official start of that is then probably when a charge sheet is served. And I was just wondering whether, yeah, I was thinking we should be a little bit more specific, but I think we should also protect staff from frivolous complaints and quite often people, they don't resign to escape from the disciplinary proceedings. They resign because new promotion opportunities have come along, etc. And we also do know that some of our councils aren't that effective in dealing with disciplinary proceedings speedily and efficiently. So I think let's leave it for now. As you said, am I reasonably satisfied? Yes. I actually welcome this paragraph as we've got it here. Thank you.
Thank you, Honourable van der Westhuizen. Thank you, Advocate Master. Jan, let's just move on to that addition there in the paragraph that follows that particular section, whereby within a certain time frame for the recovery of public funds lost due to mismanagement or misconduct. One word there, Jan. I can take the hyphen out there. Great. As well as the other one there. It just provides more clarity, colleagues. I don't think one could have a serious debate on that. But if there's any sort of other comment you'd like to make with regard to that, please, you could do so. Thank you for that, Member Andricus and the Vice Session. I'll just move on to the next paragraph. It will just a little higher quickly, just to conclude that section. It is proposed that by expressly providing for specific time frames within which this must happen will underscore the Bill's objectives of vigilant financial management and clean governance. So we're not proposing, I think there's a specific time, but I mean the committee that's going to consider these proposals will then deal with what an appropriate time period should be. And one cannot expressly state, depending how long the lots of variables that's attached to it. Anyway, the next 2.6, Jan. Clause 10, insertion of section 71B. This clause deals with staff members prohibited from holding political office by the insertion of clause 71B. In particular, clause 71B1 provides that a staff member may not hold political office in a political party, whether in a permanent, temporary or acting capacity. In turn, clause 71B2 provides that a person who has been appointed as a staff member before subsection 1 takes effect must comply with subsection 1 within 1 year of the commencement of subsection 1. If it is accepted, open brackets, and it is submitted that there are no grounds not to draw this inference, close brackets, that the primary purpose of this provision is to ensure the prevention of a conflict of interest where an employee of the municipality is also a party or is also a political party office bearer, then it is unclear why the bill provides for indulging that employee for another 12 months after it has become known that the employee is in fact conflicted. This is not congruent with the bill's purported objectives of clean governance and transparency. It is submitted that the 1 year period is arbitrary and provides no objective or rational basis for continuing the indulgence of a conflicted employee, and as the provision stands, flies in the face of the bill's objective. So it is then therefore proposed that the 12-month period should be done away with, and then if such a conflicted person is appointed, he should immediately sort of cease being a political party office bearer. That's the intention of what we trying to convey here. Andricus, I recognize you.
Yes, thank you, Chair. Chair, unfortunately, again, I don't have all the documents open in front of me. Can I just ask, is it from the date that somebody is appointed, or is it from the date that this bill, or once adopted, comes into effect? If it's just what I would call a transitional arrangement, because currently we've got no laws covering this, and we are moving towards a situation where we will have legislation prohibiting this conflict of interest, then I can understand the transitional kind of arrangement to say, oh, you know, this may be a general thing currently, and we give those in that position, and a year from when this law is enacted, this act is enacted. If it's the date of appointment, then I fully agree that obviously you apply for a position knowing quite well that once you're appointed, you should vacate that political office. So perhaps if Advocate Maastop could just help us, if it's from, as you stated, Chair, the date that the staff member gets appointed, then or takes up duty, then I fully understand and I fully agree. But if it's a transitional arrangement, I can actually live with what I find currently in the proposed bill, or in the bill.
Thank you, Advocate. Advocate Maastop, would you indulge us in your commentary with regard to that? Now, I think that if it's transitionary and the person is already in the position, and then there may be, but 12 months is arbitrary, as Advocate Maastop has so eloquently pointed out. So if the conflicted person is already in the employ, then perhaps he should immediately institute sort of measures to terminate that sort of office that he holds in the political party. But Advocate Maastop can just add to that or comment on that, please.
Chairperson, in fact, the section assists us. If I could maybe just ask my colleague Johan to just scroll slightly down. I just want to see the top section of that paragraph, because my understanding from the text is that a person who has been appointed before subsection 1 takes effect. So if the person is appointed today, and then it says, must comply with subsection 1 within 1 year of the commencement of subsection 1. So if this bill is signed off on the 10th of July, then let's just keep that date, that example in mind. The person must then comply. If the person is appointed today, the person must comply with the 12-month period within 1 year of the 10th of July. So it starts then, and not the date of appointment. That's maybe the first observation, but I didn't put the following in there, but I may want to just give some context that formed this thinking as well. Because you see, Chair, I go on what the bill purports to put out there, which is transparency and clean governance, etc. We do know, especially at local government level, how there is a scramble for position, because that position in political party office will probably open the road for employment at the council level. So if a person is tolerated for 12 months after holding 2 chairs or 2 positions, if you like, even the perception from public side is one that one shouldn't compromise. The perception from public side would then be that I can still vie for political office, contest with my party colleagues, because there's a job open for me. I think the intention is to also just dismiss that perception. So if we continue to tolerate someone for 12 months who is conflicted, knowingly conflicted, then we also send out the wrong message. So I am saying, how did we even get to 12 months? Why not 12 hours? Why not 12 minutes after the inception? What message do we send out? This indulgence, this tolerance for conflicted people to be accommodated in official public institutions. How did we get to 12 months? I am saying that is arbitrary. It's a thumbsuck. And we should maybe propose either an immediate or, because we are a tolerant society, maybe 30 days so that the person can find another job or something more reasonable and something that doesn't compromise public perception. But the direct observation as far as Member van der Westhuizen is concerned, it is with the inception of subsection 1, which is 12 months from the date of the commencement of the Act.
Thank you, Advocate Master. Honourable van der Westhuizen, I see you have a hand up.
Yes, thank you, Chair. Chair, can I just say, I don't find the 12 months completely arbitrary. We do know that meetings where office bearers are elected for many positions, whether it's in a sectional title development or whatever, happens once a year. And my impression of this is that, you know, if you find yourself already in that position where you have been nominated and where people have elected you in a democratic way to serve in a specific position, let's say you're the treasurer or you're a chairperson or what, then you would not have made yourself available for that position knowing that the law prohibits this. But now that, you know, currently it is being allowed, there's a new law coming in which will prohibit this. So next time you will not put up, or when people want to nominate you, you say, sorry, I'm a staff member, and in terms of the law, I cannot be elected as a treasurer, whatever the case may be. But this is now where people have, let's say, during the course of the last 12 months or the previous 12 months, where they've quite innocently within the law, they have made themselves available, or they accepted nomination, they've been elected. And I think at the next AGM, obviously, the situation can be or should be normalized, if I can use that term. So the 12 months, not quite arbitrarily. We know that such meetings often happen in a 12-month cycle. And secondly, I think it is just to allow those people that are currently serving to vacate office in an ordinary way at the next AGM, as might have been the case in any case. Thank you.
Thank you, Honourable van der Westhuizen. My view on this instance, I go along with Advocate Maasdorp in a sense that you elect either to become an employee or to become a political office bearer. And if you elect to take up a employed paid position within the council, you must make a decision whether you want to continue to be a political office bearer or vice versa. And therefore, I don't think that we should have this sort of protracted tolerance for the conflict of interest. So nothing prevents you from resigning from that particular office because you have exercised your election to become a paid employee within the municipality. And therefore, I would go along with the proposal that because, as Advocate Maasdorp was saying, that we're in a tolerant society, that we must give a reasonable time within 30 days. Either resign your position from government or resign your position from party in terms of your elected sort of office that you've been elected to. So I would go along and I would strongly support such an amendment where possible. Andrikus, I see you.
Sorry, Chair. I think one of us is misreading a section here. The clause provides that a person who has been appointed as a staff member before this law takes effect. I fully agree with you. In future, if you want to apply for a position in a municipality, you must clear that position with your party before you take up office. But in this case, really, my reading of this is that it's quite clear before the subsection takes effect, not before you take office or not before you accept the position. It deals with the 12 months deals with the legislation and not with your date of appointment. But if I'm wrong, please point that out to me where the words of date of appointment is stated. I don't see that in this proposed legislation.
You're right, Honourable van der Westhuizen, and there's no sort of clear reference to date of appointment, but I'd like to draw your attention to the fact that when this amendment becomes law, from that date onwards, the 12-month period will commence. So it is not from a date of appointment, is when this particular sort of amendments are enacted, and only then the 12 months comes into effect. And as Advocate Master so eloquently pointed out, that you may be 6 months into your political office by then, but you were given a further 12 months to exit that particular week. So the 12 months is arbitrary. It doesn't make sense, I mean, we could say fine for a transitional period, say 3 months. Within 3 months, you must vacate and resign your political office. Or if you refuse to do so, you must then resign as an employee. But 12 months is way too tolerant and for too long to have a conflicted person. And we know in our municipalities, the branch chairperson is an employee, but the mayor is an ordinary member of the branch. So there's that uses his political office to exercise influence over the mayor or whoever else there may be. And that's the reality out there in some municipalities. So we're not going to agree on the 12 months, but I strongly believe that the 12 months is completely arbitrary. I see another hand there.
Honorable Maseko.
Okay, I don't see your name yet. Honorable Maseko, please proceed.
No, Chair, I just wanted to say I agree with you and Advocate Masdorp, because until you get to face the scenario of an individual in two positions, those two positions, is then that you can understand why Advocate Masdorp and yourself says that in Cedarburg municipality, we have that scenario. It's horror movie if you look at it. So just not to waste time for us to continue, I agree with you and Advocate Masdorp. I think that it will be how we record it in our negotiating mandate. Thank you very much, Chair.
Thank you, Honorable Maseko. Yeah, so, okay. Thank you. Well, we'll move on to the next clause, 2.7. Thank you for that. This clause seeks to amend Section 106 of the Principles Act by the substitution of Section 5 of the following subsection. We know this Section 106 investigations, where an MEC fails to conduct an investigation within 90 days, notwithstanding a request from the minister may, in terms of this section, conduct such investigation. Again, it is observed that whereas the MEC is compelled to act, the minister only has the discretion to do so in relation to the same matter. This, it is submitted, is incongruent with the compliance objectives. In addition, the bill is silent on any consequences in relation to the MEC for his or failure to act. It is proposed that the bill provides for Where we go. Johan, can you just move a little higher, please? Let's just please be excused on the meeting. Who's this? Okay, Isaac, fine. Yeah, you may go. Thank you.
Thank you.
Right, it is proposed that the bill provides for a compelling the minister to take appropriate steps where the MSC fails to do so. Accountability by the MSC where usually fails to take appropriate steps. I'm reminded of a comment here made by Mr. Maepa yesterday with regard to who's the appointing authority insofar as the MSC is concerned? Is it the minister or the premier? And maybe we could, I don't know whether we should either, pass on that sort of responsibility either to the minister or to the premier when it's, to take appropriate steps against an MSC who fails to institute Section 106 investigations. I don't know, just putting it out there. Andrikas, and then I have Honourable Maseko.
Thank you, Chair. Can I just, a question, and then I would like to propose something. The 90-day period, is that 90 days from being, from the minister, the national minister requesting an MEC to conduct an investigation? Is it from the request, or is it within 90 days of, the MEC becoming aware of such an appointment? Perhaps if I could just first get clarity before I comment any further. Thank you, Chair.
Okay, Honourable Maseko. Honourable Maseko, is that an old hand or is it the new hand? I suppose it's an old hand. Section 106 investigations. That is my understanding is that when it becomes when the minister becomes aware of a matter that would warrant such an investigation, and not when the minister instructs the MEC to conduct such an investigation. So if there's a contrary view, please express it. It is not the minister that instructs, you must carry out the investigation. It's the awareness that befalls MEC of the malfeasance or malpractices or maladministration that is purported to have occurred in a particular municipality. That's the interpretation of that, Andrikas.
May I just come in here?
Yes, for sure.
Yes, thank you, Chair. What I found in practice is that some of these investigations, unfortunately, and I really want to stress unfortunately, takes a number of months to complete. Because obviously the MEC must ask for documentary evidence, supporting documents, and my impression is that the MEC's ability to conduct these kinds of investigations quite often is quite limited. So I was wondering whether we shouldn't propose that this clause be amended to say where an MEC fails to initiate an investigation, and then I would like to say perhaps the 90 days should even be a bit shorter, of the date on which the MEC becomes aware of such an appointment. So I would like to delete the words conduct but replace that with the words where an MEC fails to initiate an investigation. I'm open to a shorter time frame than 90 days of the date on which the MEC becomes aware of such an appointment, because my impression is that the MEC must be informed by the local government of such appointments. But if a council, for example, play games and they don't inform the MEC, etc., I don't think we can therefore, put such an MEC in a disadvantaged position. So those are my suggestions just for your consideration, Chair.
Right. Thank you. The Minister may, in terms of this section, conduct such an investigation. Okay. I think that we will come back to that, and I don't think it's insertion, but I have Advocate Master, who is more school to comment on that. Advocate Master.
Thank you, Chairperson. I completely understand the sentiment that Member van der Westhuizen seeks to protect, the one of investigations taking very long, etc., and he is quite open to even a shorter period. I noticed that my colleague Johan Kutsi has inserted the word initiate, so that the sentence now reads as a proposal: when MEC fails to initiate initiate an investigation within 90 days. Now, and I'm very mindful of what Member van der Westhuizen said now, but now you see, Chairperson, let me just put the following out there as a context. The dynamics, the political dynamics at local government level, we are all very familiar with it. And I'm sure that the two members who spoke, including the chair, are very, very much more conversant with the dynamics at the local level between political party members and officials in municipalities. If a staff member is facing disciplinary action, or if there's a complaint against a staff member, again, party politics creep in, and investigations are incidents. Investigations can even become tools of manipulation, where it is never finalized, or if it's a person from another party, it is expeditiously finalized. And that is how processes and how system is being abused. Now, that is context. One is not naive about these things, and the law must speak to these realities. Now, if we say, let's take a scenario with Member van der Westhuizen's proposal. When MEC fails to initiate an investigation within 90 days, notwithstanding a request from the minister, the minister may conduct that investigation. I would want an MEC can start an investigation on day one, but there can be means and ways to prolong, protract, and drag an investigation forever and a day. I would, however, mindful especially on what Member van der Westhuizen said insofar as it pertains to the length of investigations. And like I now say, the potential for abuse of system and process. I would suggest we should in fact say, where an MEC fails, because remember, an MEC has all the resources at his or her disposal, all staff members at his or her disposal to do an investigation. I would in fact say that when MEC fails to finalize an investigation within 90 days, notwithstanding a request from the minister may step in to finalize that investigation. That will again suit and be congruent with the objective of the bill, which is clean governance, openness, expeditious finality of financial management issues and the perception from the outside that if you do wrong, you will be processed through the disciplinary processes. So let's impose an imperative on an MEC. Finalize this within 3 months.
Yeah.
90 days is in that context a suitable period because, like I said, an MEC has all the resources at his or her disposal, including public funds, to outsource an investigatory agent. Thank you, Chairperson.
Thank you, Advocate Master. So we say if an MEC fails to conduct and finalize an investigation within 90 days, I think we should also be mindful in the context of what Advocate Master was saying about recent case law here, Makamba versus the Minister Anton Bredel's case regarding the investigation, the Section 106 investigation in the Makamba municipality, where the scenario sketched by Advocate Master was sort of played out, and it went to court subsequently. So I think it will accommodate the concerns raised by Honourable van der Westhuizen, if we could insert Johan there, conduct and finalize an investigation within 90 days, notwithstanding the obligation that is imposed on the minister, that would then substitute, as Advocate Master has sort of commented yesterday, and it's incorporated here, that compelling the minister to take appropriate steps, in terms of the finalization or the investigation of a particular matter, as is stated lower down the paragraph. Andricus?
Yes, thank you, Chair. I just wish the MECs well, but perhaps can I just ask, my second question is, when does this period of 90 days start? And are we talking about 90 days from the request from the minister, or are we talking about 90 days since the decision to appoint has been taken? Are we talking 90 days of the MEC being informed of that appointment? Can I also just point out, and I fully agree with the urge and the urgency that I hear, that these things should not be dragged out as they are, but that normally councils are given 21 days to submit the let's say the scores in the interviews, or to submit the information required, submit the composition or the background of the panel members that sat, etc. So I'm just wondering whether we have clarity, or whether, if this is left as it is, whether the National Assembly had clarity on when the 90 days start.
Yeah, it's a good question, and I think that don't think that there will be a one size fit all. There will always be individual circumstances that will dictate when a matter is finalized also. But I think that what is attempted here is just broadly to put in place parameters within which these matters should be dealt with and finalized. There are always individual circumstances that would necessitate that we should go sometimes beyond the 90 days to finalize matters. But it's 90 days is not arbitrary, I would want to believe, but notwithstanding that, as it was alluded to earlier, that the resources are available to have matters finalized as expeditiously as possible. In terms of when the convention of the 90 days, I'm not going to commit myself to give you a definitive answer as to when does it start. Advocate Maasor.
Thank you, Chairperson. I must confess that I did not read the provision in the Principal Act. As we know, this is just an attempt by the bill to amend some provisions in the Principal Act. So, and this is subsection 5. And I am just not familiar now, I don't have it with me in front of me now, what subsection 4, subsection 3, 2, and 1 may say. There may be indications there. But having said that, an investigation can only start when a formal complaint is submitted, is lodged, a complaint under oath, an affidavit. So if an MEC receives a complaint, that's when the investigation starts. Having said that, I may need to just inform myself with more reading, because it says when MEC fails to conduct an investigation within 90 days, in other words, an investigation from the day of receiving the complaint and 90 days later, notwithstanding a request from the minister. So I'm just not sure at what point the minister is obliged to request the MEC to start this investigation. Because an MEC may receive a complaint of misconduct and initiate investigation. Why should the minister request that if the MEC is already busy with the investigation? So there's just a bit of vagueness for me at this stage. However, despite that, I think it is still prudent for us to recommend and now mandate that we would like for matters to be sped up and for finalization of investigations within 90 days of receipt of a complaint. Although it's not written here, but that is the inference that one would want to read, that an MEC must do and finalize an investigation within 3 months, which I believe, I submit in fact, is sufficient time to commence and finalize an investigation, mindful of the availability of resources at MEC level.
Thank you, Advocate Maasor. Colleagues, I think that we move beyond this particular clause now, being sort of fully alert and alive to the comments made by Honourable Hendrikus, and I think clarity will be obtained, during with the passage of time, I suppose, if one goes back to the Principal Act. I think there will be, sufficient guidelines as to when does such a investigation would be deemed to commence. Johan, can you move on to section 2.8?
Chairperson, may I just quickly ask that we then, the committee is happy to include to finalize.
Yes.
Is that fine? Okay, thank you, Chair. I'll move.
Clause 13, amendment of section 120. The minister is also obligated to make regulations in other sections as proposed. Section 57A. It is proposed that all trust references are completed and corrected. That's stylistic. Let's just move on, Jan. Clause 14, amendment of Schedule 1, voting at meetings. From the text of the bill, it is not clear how non-compliance will be detected and how and by whom this will be enforced. Mindful of the bill's purported objectives of accountability and good governance, it is also not so clear what consequences will ensure inside the council externally and for council who does in fact vote contrary to legislation. It is submitted that notwithstanding the bill's stated objectives, it falls short of its own mark by not providing for follow-through in instances of non-compliance, and that an opportunity exists in the bill for the creation of a new statutory of offences as a deterrent to non-compliance, be it in relation to staff member, councillor, or an MSc. Just a comment with regard to a possible shortcoming, and I don't think that we will be specific in that regard as to what the consequences should be. One would assume that there should either be an amendment to the Councillor's Code of Conduct, or staff members' disciplinary code of conduct, and the MSc, public protector, or the Premier. I don't know. I mean, those are just all the possibilities that should be considered in that context. 2.10, Clause 16, repeal of Act 7 of 2011. This provision is incomplete. It is proposed that Section 82 of the Municipal Structures Act also be repealed. If said section is not repealed, there will be conflicting provision in the two acts. Right. So, colleague, that's the composite sort of mandate that we have formulated based on the engagement yesterday with the department and the inputs of Advocate Master that would underpin our negotiating mandate. Are there any comments that, having gone through the complete report, members would like to make? Anything that we have left out that we could have possibly have included? Johan Vermeulen.
Chairperson, thank you. I think I just have a very small technical thing that I just want to mention. Johan, if you can just scroll to 2.2, please. The very last paragraph there. 2.2. Yes, down. Yes, there we go. You see that very last sentence there. It says it is proposed to omit the cross-reference to subsection 7B. I think there's just a bracket that must be closed there behind the B. That's all.
Thank you so much, Johan.
Thank you.
I recognize Honourable Makamba Boita.
Chair, thank you very much, and my apologies for probably taking the meeting break. I had problems with my network yesterday. I just want clarity on the issue because I see the bill is very silent on the appointment of managers permanently who reports to the municipal manager. Instead, the bill has actually vested that right to the municipal council to make a decision whether they must employ the person permanent or on contract basis, which can in the end result in unfairness in that whole process. So I'm just making that comment, not sure if it was covered in the yesterday's meeting since I had problems with the network. Thank you.
Okay. Thank you for that question. That specific comment that you've made, there was no sort of differing view in terms of that particular clause or amendment. The meeting expressed its support for it, hence it is not contained in our negotiating mandate. Right. So, colleagues, with that said, can I have a proposal that we accept the report as it was presented to us this morning as our negotiating mandate to be taken to the NCOP? I see Honourable Hendrikus van der Westhuizen.
Thank you, Chair. I believe there have been one or two slight amendments, and with those amendments, I support that this document be submitted as the Western Cape's negotiating mandate to our representatives.
Thank you so much, Honourable van der Westhuizen. Is there a seconder for that?
Yes, Chair, I'm sorry, my hand is not working correctly, so I second the proposal by member. Yes.
Thank you, Honourable Maseko. Colleagues, the report as it was presented and dealt with today with all its amendments have been agreed to by this committee as our negotiating mandate to our delegate to the NCOP. Honourable Makamba Boita.
Sure, I just need clarity on this matter that we are having at hand. Are we in the process of supporting the bill or not supporting the bill? Or is it a process of submitting the report to the NCOP or what? I need clarity on that.
Yeah.
Thank you.
I think, yes, that the first paragraph reads, and the second paragraph, the Standing Committee on Local Government, having considered the subject of the Local Government Municipal Systems Amendment Bill, blah, 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 referred to the committee in accordance with Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to support the bill. The committee further proposes the following amendments and those that we've gone through. So, Honourable Makamba Boita, we do support the bill, subject, with these amendments. But notwithstanding that, we will have further engagements where we will agree on a final mandate that we would confer upon our delegation to the NCOP. Honourable Makamba Boita?
No, Chair, I'm clear, but I just wanted to find clarity on that because I wanted to express the minority view of the EFF on that note, but from what you are saying, this is not a final draft because we wish to express our minority view not to support the bill if that is the process.
We were not there yet,
No.
This will be taken to all the provinces will have the negotiating mandate, and we will get all that feedback. And then once we get all the feedback, some of our recommendations may be accepted, some may not be. And only at that stage, once we gotten the feedback from all the provinces, and the final the conclusion of the final deliberations between the standing committee or whatever committee they call select committee, then we will decide on our final mandate. And at that stage, you could express the minority view that you may have. Okay. Thank you. So, colleagues, seeing that was the only item on the agenda, may I thank all of you who have played an invaluable role and made substantive contribution for us to arrive at this stage. And I know the time frames were very tight. And Johan Kutsi in particular, I'd like to thank you for putting all these things together in such a short space of time and get the public participation process going. I'd like to thank you so much for the role you played in getting us to where we are today. To Advocate Maasdorp, thanks a lot for your invaluable contribution that you have made to strengthen our mandate to the NCOP, and I think your contribution to a large extent has enhanced the quality of our mandate, and for that I'd like to thank you as the committee, express our heartfelt appreciation for that. Jan van Gellen, thank you for the behind the scenes eagle eye and technical compliance with the process. It's much appreciated. And of course to Candice and Mfundu for your behind the scenes support and backup. It's much appreciated. And lastly, to my colleagues, thanks a lot for your contribution and support. And with that, it is now 10:27, much longer than we anticipated this meeting to last, but thank you so much for indulging myself and others who have spoken on the platform. With that, colleagues, have a lovely day, and I'd like to declare the meeting closed.
Thank you. Thank you, Chairperson.